Hi Taslim, this is Sarah Bickle.
I'm Laura Bresson.
And we'll be doing Ethical Dilemma 10.
So our ethical dilemma is Dr. Tell worked for a woman for several months on issues related to depression, anxiety, and relationship issues. During one session, the patient indicated that her boyfriend has lost interest in sex and became more involved with online pornography. While discussing these issues, the patient suddenly stopped talking. Dr. Tell allowed several moments to pass before asking the patient what was happening. The client indicated that she was hesitant to speak about the issue for fear of a breach of confidentiality. Dr. Tell reminded her about confidentiality and the laws in Pennsylvania that would override it. The client continued to struggle. She eventually blurted out that during a heated discussion, her boyfriend indicated that looking at online pornography was not as bad as what his uncle did. She went on to detail how her boyfriend described how his uncle was involved in collecting and distributing child pornography, but remained faithful to his aunt. The client's boyfriend expressed that she should never discuss this with anyone. The client asked if she could just give Dr. Tell the information about the uncle so that she could report it to the authorities and leave her out of the situation. The client is feeling very helpless and vulnerable about this bind. So with this ethical dilemma, we have three issues to take into consideration. The first one is, does Dr. Tell have the duty to report the implication of the uncle in children pornography to the police and or child protective services? Does reporting this information put the confidentiality at risk is the second issue that we will have to look at. And the third one is it adequate to invite the boyfriend in therapy? In the process of ethical decision making, the first step is to identify the individuals and groups affected by the decision. The first person to be involved is Dr. Tell, then the client's boyfriend, the client's boyfriend, uncle, aunt, and overall family, the children featured in the pornography, and Dr. Tell's supervisor. The second step is to identify the ethically relevant issues and practices. So the first issue is the quality of the information that we have from the client on this issue of children pornography. Do we have enough information, and how likely is the information true? How sure we can be about the information that our client gave us. The second issue is the confidentiality. How broad and severe a breach in confidentiality is required by the law, and what is left to the personal conscience of the people involved in the situation. In this case, Dr. Tell, the client, the boyfriend, and the overall family. Then we have to take into account the best interests of the client, especially her safety and the quality of her relationships and her family, for example, the reputation of the uncle, and to also take into account whether we want to bring closure or maybe cause re-traumatization of the children. Assuming the information is correct, we have a moral duty to provide moral justice to the children. So, whose responsibility is to report, and what are the limitations? The third step is to consider our own biases regarding the situation. First of all is our relationship with the client. The second one is the relationship with the legal system. And then we have to look at our reluctance and triggered. Are we hesitant to push for what we feel needs to be done? Should we consult supervision? Is our judgment clouded by being too close to the issue in some way? Are we worried that the situation may backfire? The fourth step is the development of courses of action. So with Sarah, we came with 4 possible courses of action. The first one is to arrange for a session with the boyfriend and the client, which would respect the code of ethics, Number 118, respecting the wishes of the client to involve third parties, which would enable us to gather more information on the situation, whether the information is true. And we want to encourage the client to report together with her boyfriend as stipulated in the Code of Ethics 146, which is the extended responsibility of the psychologist to promote responsibility in clients. The second course of action is to arrange for a session with the boyfriend and the client, gather more information, but this time to keep both the client and her boyfriend off the record as much as possible, as stated in the Code of Ethics 245, which is to share the minimum required amount of information with the police. The third course of action is to report the information independently without including the boyfriend, which means that we would also leave the client off the record. The fourth course of action is to not report the information. The fifth step is to take a look at the short-term, ongoing, and long-term risks and benefits of each course of action. So for the first course of action, which is to arrange for a session between the boyfriend and the client to gather more information and to encourage the boyfriend and the client to report together, the short-term risks are further strain on the relationship between the client and her boyfriend. The long-term risks are a possible breakup between the client and her boyfriend, since her boyfriend wasn't willing to share this information with his girlfriend in the first place. We also have to take into consideration the breach of confidentiality between the boyfriend and his family, since the boyfriend was not supposed to share this information with his girlfriend, which may lead to a compromised safety for the boyfriend and the client. The ongoing risks are the safety of the client and a further strain on her relationship. However, we have the benefit of being able to make a stronger case for the report of the children's pornography, the confirmation of the validity of the information, the opportunity to have a fruitful conversation between the client and her boyfriend, which could make their relationship stronger. The second course of action has pretty much the same risks and benefits as the first one, except for the fact that we are respecting the client wishes to not be involved with reporting this information, and the boyfriends as well, although this choice may include a legal bind, as they may be under the legal obligation to report. We are also protecting both the client and her boyfriend from possible harm coming from the boyfriend family, especially from the uncle.
So for reporting the information independently, without including the boyfriend or the girlfriend, the client, there's the short-term risks of we may not be able to gather enough information without the boyfriend to make a successful claim, and we may miss out on the opportunity for the client and the boyfriend to have a fruitful conversation about their issues. For the long-term risks, there's a lack of resolution on this issue may deteriorate the well-being of the client, who's already feeling vulnerable and helpless in the situation. For ongoing risks, the abuse of the children and the trauma that may carry on. And the benefits are that we respect the client's wish not to be involved in the report, and we avoid escalation of relationship issues. For the final step of not reporting the information, we risk deterioration of the well-being of the client, who's already feeling quite helpless and vulnerable, both with the issues of a relationship and the situation. For ongoing risks, there's abuse and trauma of the children, which may carry on if nothing's done about this situation. And for the benefits, we avoid the stress and trauma and all the together upheaval of legal proceedings and emotions for everyone. This includes the client, her boyfriend's family, and the children who, although they may get some closure from this, they might also be re-traumatized. So for the choice of course of actions, we're going to want to discuss moral and legal obligations with the client. So whose responsibility is it to report? We want to review the limits to the confidentiality, the potential courses of actions and outcomes, and obtain any additional information. So why is this suspected? Maybe we should explore some motivations for making this claim. How long ago was it? Is the uncle still around children? What is the nature of his relationship with the children? Any further identifying information about the uncle, and whether there's any specific children involved, any others involved. Thirdly, we want to arrange support. So we're going to consult our supervision, consider connecting the client, boyfriend, and family with the therapeutic resources. Then we're going to file the report. And fifth, we'll have a continued responsibility. So we're going to want to keep a going record of the relevant files, provide follow-up support, and prepare ourselves for to be available for legal proceedings. So this is just the multiple steps of the course of action. So let's break that down. So for whose responsibility it is to report, in the initial case, it wasn't mentioned that we're in Pennsylvania, but we wanted to cover our basis for both Ontario and Pennsylvania because there's a big difference between these two states. So in Ontario, all parties have a legal obligation to support because any adult who has reasonable grounds to suspect child abuse must report in Ontario. However, in Pennsylvania, none of the parties in this particular case will be required to report because only specific professionals have the duty to report, and they're only responsible if they are directly in charge of the care of the child or aware of a specific child which is being abused. Otherwise, the info obtained under confidentiality isn't obligated to be reported for merely suspected abuse. We'll want to discuss the severity of the situation and the possible legal implications which may weigh on the client. However, we need to be careful not to manipulate or pressure the client, as this would also be a violation of the Code of Ethics. With regards to the limitations of confidentiality, we're going to want to obtain the consent of the client with regards to involving other parties. So there are multiple complications having multiple relationships by bringing in the boyfriend. We're going to have to refine consent throughout the process as new information arises and as new parties are involved. And we're going to want to discuss the risks of confidentiality breaches because although we are going to do our due diligence to maintain confidentiality, there's always the potential that the family will find out anyways that there has been a report made. For obtaining additional information, we want to assess out the validity of this claim. So because it was made under the context of a fight, it could be that the boyfriend is just trying to throw the attention off of himself. It could be that he misconstrued the information originally. And it could be that the client herself has some ulterior motivations for making this claim. So we definitely would not want to make this claim unless we have reasonable grounds to be sure that we do have valid information. Furthermore, we're going to want to know some specific features about the assault. So we need to know how long ago, because if the child is now 18, there is no duty to report either in Pennsylvania or in Ontario. If the uncle is still around children, however, there might be a duty to report because we have reasonable grounds to suspect that other children might be at harm. Again, if there's any specific children in Pennsylvania, this will change whether or not we're going to make the report at all. And also the nature of the relationship with the uncle to the child. So if they are not the direct caregiver, then they're not technically a perpetrator under the laws of Pennsylvania. That doesn't mean that they cannot still be fined. It just means that there will be a different severity and different legal proceedings that'll follow. So we'll definitely want to know that. We need to collect information because without a certain degree of identifying information, the case might not go through whatsoever. So depending on the state or province, this might vary, but some examples of information that we'll need is the child's information, age, school, and current location. We'll need descriptive details about the nature and extent of the abuse, where the incident occurred, risks of abuse. We'll need information about the caregiver and or the offender, if they're not the same person, the name, age, address, possible quotations, the involvement of drug use, as well as our own information as the reporter. We're going to need to arrange support and file and follow up. So for arranging support, we need to ensure our own emotional rigor throughout. So having support of our supervisor is going to do that for us, but also we need to be very thorough in our considerations and make sure that we have a professional consensus before reporting. We have a duty to connect with the client with therapeutic resources. Everyone we're involved in, we want to make sure that they are emotionally fine throughout the process and well informed about the proceedings. Considering filing, depending on the information that we get from the boyfriend, we may or may not have a duty to report. We'll have a permissive duty to report, so that means that we can report if we want to, which, as we'll explore further on, we will likely want to. Because we have a duty to report harm, we'll have protection because we're acting in good faith. However, if we decide that we don't want to do this, we are protected to our own moral rights to liberty. So we do have the option not to report if we don't want to, and the conditions are such that allows that. For follow-up, we have a duty to keep secure records. So this is for 10 years after we have the client in our care, or longer if the law requires, which in this case we might. We're going to have to be very careful about the records that we keep so that it cannot be misused. And we have a duty to maintain care, either directly with the client following the proceedings, if not just to connect them with other professionals who can provide that care.
Okay, the next step and the last step that we can do with the information we were provided with is to choose a course of action among the courses of action that we explained before. So we choose to go with the course of action number 1, which involves inviting the boyfriend to discuss the matter at hand and encourage both the boyfriend and the client to report the abuse. We chose to do that for 3 main reasons, which are that they would both act from good intent, which would grant them criminal and civil protection, because since all parties in this situation have a legal duty to report, if they don't report, they may be susceptible to legal proceeding, whereas if they act first from good intent, it would grant them criminal and civil protection. There is also we also chose to go with this course of action because there is a strong possibility to have a better chance at resolving the issues in their relationship, and we believe that this is a strong enough possibility to try it, even though in the short term it may deteriorate their relationship. In the long term, there is, we think, a strong enough likelihood that their relationship would grow stronger. The third reason is that the only way to make a strong claim to keep the children from further abuse, to restore justice, and fulfill our duty to report is to involve the boyfriend, because only the boyfriend has the information that that Sarah said earlier about the addresses, the names, and so on, and in this situation, only the boyfriend would possibly have enough information for us to make a strong claim, if a claim at all. So that's it for the ethical dilemma number 10. Thank you for listening.
And have an amazing rest of your August. Bye.
Bye.